A settlement counsel is an attorney who restricts his or her practice on a particular case to saying, I am responsible for trying to settle this case. Working with the client and then working with the other side, you focus all of your energy on finding solutions that work, representing one party in the negotiation process. I started in the area by being a trial lawyer. When I graduated law school, like most young lawyers, people said, what do you do? I said, I'm a trial lawyer. Of course, I'd never tried a case in my life, but aspirations are part of it. I wanted to be a trial lawyer, so I said it. After a while, measured in years, I understood that most of the time in most cases, it never really went to trial. Most of the time you did discovery and then settlement. Then people said, what do you do? And I would say, well, I'm a litigator. And they would say, ooh, what's that? And then I would describe the litigation process. After a while, measured again in years, I realized that in most cases, the end point wasn't me going to trial, but the case settling. So in 1987, I said, maybe I should spend my time and energy learning not how to try cases, but how to settle cases. I then spent 2 years trying every form of ADR then known to the legal community. They included direct party negotiation, mediation, evaluative mediation, black box neutral expert, executive mini trials, a whole range of technologies, of approaches to settle cases. 1989, I announced to the world we had our firm's ADR practice group. And in 1990, I started restricting my practice to being settlement counsel. The way that I would do it would be to approach clients, firm clients, or in some cases, our firm would be invited in to make a presentation about why we should be hired as their counsel. And my pitch was, lots of good trial lawyers that you've met today. You want a litigator, you want a trial lawyer, hire any one of them. But if your company is interested in settling this case, hire me. Why? Because I'm good. Because I've spent more than 2 years learning not how to try cases, but how to settle cases. And in every case in the business community, there should be somebody who's focusing on settling this case. Thinking about the business objectives, thinking about what it is that you're trying to do, thinking about what it would mean to succeed in getting rid of this case. That person is called settlement counsel. That's what you should do, is to hire me. That's how I started. And that's exactly the process, is you meet with the client to ask that question. What's the nature of this dispute? What are you trying to accomplish? What would success mean? And then working with the client, you set goals and objectives. For the plaintiffs, it can be we want some money. Almost always it's more than just that. For the defense, it can be, we don't want to pay very much money. And usually it's part of that, but then a lot more. Whether it's plaintiffs or defendants, in the business community, business people have business objectives that they're trying to satisfy. And litigation is a very imperfect tool for meeting business objectives. So once you've established what the client is trying to do, then you can use a whole range of tools to achieve those objectives. Collaborating lawyering started later. I started doing settlement counsel work publicly in 1989, 1990. Collaborative law in the United States is really a four-part agreement. The lawyer and the client on one side, the lawyer and the client on the other side, enter into a four-way agreement that all of them will work only towards settling the case, and if the case is going to be tried, then the lawyers will resign and somebody else will try the case. In a sense, settlement counsel is like unilateral disarmament. It doesn't require anybody on the other side to agree. All it requires is for my client to have me as settlement counsel and anybody else as their trial lawyer. Now, what typically happens is I pick up the phone and I call the outside counsel on the other side. And I say, good afternoon, I'm Jim McGuire, I represent Acme Company. I'm their settlement counsel. I need to speak to that person, if anyone, on your side who's authorized and interested in discussing settlement. Now, typically all that happens in that first phone call is outside counsel says something like, let me see if I get this straight. You're settlement counsel, you're not the trial lawyer, and you want to talk to that person, if anyone on our side, that's authorized and interested in talking about settlement. And I say, yep, that's it. Generally, they then hang up the phone. And the next phone call they make is to in-house general counsel. And it goes something like this. Joe, I just got off the phone with this guy, McGuire, and he says that he's settlement counsel, and then they repeat exactly what I've said. The general counsel then says, why, that would be me, right? That's my job. For this corporation, I'm the person that's responsible for looking over all the litigation matters of the corporation. And if there's to be a settlement, I look out for the corporate interest. Now, sometimes the next phone call will then be from general counsel on the other side to me saying, my name is Barry, I am general counsel of Acme Company. I understand that you're interested in discussing settlement. And the conversation would start. That's how the process would typically start. Now, not always, but almost always, as soon as I said I'm settlement counsel, the other side either identified someone as settlement counsel or they invented somebody to fill that role. So back to your question, collaborative law requires an agreement before you do anything. Settlement counsel requires only an agreement with the client that they want to settle the case and they want me to do it. Most of the time, settlement counsel begets settlement counsel. If one side has it, the other side will create it. And then you end up with two people who say that they're both focused on trying to settle the case. Doesn't make any difference, because if the other side has the same lawyer as trial counsel and as settlement counsel, that describes the way it happens in most cases involving negotiations today. It's an important question, and it's a question of describing your rules and not crossing lines or rules. Your job as settlement counsel is to be an advocate for one party. Okay, that's your assigned role. By agreement, your job is not to be litigation counsel or trial counsel. So you start with a three-person agreement. The client, who directs everything, says to the litigator, you are not in charge of settlement. Okay? So any phone call that comes in to the litigator that talks about settlement, you refer to Jim, he's settlement counsel. At the same time, I agree with the trial lawyer. Any topic that has to do with trying the case, staying discovery, proceeding with discovery, exchanging documents for trial purposes, anything that has to do with the litigation process, I say I don't know anything about that. Even if in the first phone call, when I say I'm settlement counsel, we want to talk about settling the case, if they say, does that mean you want to put the litigation on hold? I say, I'm not trial counsel. I don't speak for trial counsel. If it's anything to do with the discovery process, deal with them. Now, in the same way, when we move into the settlement negotiations, as settlement counsel, I may, and frequently did, use mediators as a service, because as a mediator now, I know that even if you have settlement counsel on one side or on both sides, that's the same thing as saying I have two corporate entities that are interested in settling this case. Lots of cases have people that are interested in settling that fail to settle because they can't communicate effectively. That's why we use mediation. So in the 1990s, I was a great consumer of mediation services. Now, I would be clear in my own mind, I'm settlement counsel, I'm an advocate, I'm not trying to become a mediator in this case. And most of the time, I had no difficulty preserving that view. Occasionally, because I was a trained mediator, I would have my own insights into how the mediator might do his or her job a little bit better. But that's probably not different from, other trial lawyers or other lawyers who say, what you're doing, Mr. Mediator, isn't so effective. But in terms of crossing over the line, I cared a lot about the mediation process. And while it is facilitated negotiation, it's important that people work in their assigned role. So use mediation, use the mediator, use them effectively, but don't try to wear two hats at the same time. The ethics of being settlement counsel has two elements to it. The first, obviously, and the most important one is you're not the client. So any communication of authority to settle has to be with the informed consent of the client. In terms of the process, almost always, settlement counsel will agree with the client in advance either a specific dollar amount or a range or other terms that they're looking for in the course of the settlement. Doesn't make any difference if it's the plaintiff or the defendant. It only makes sense to engage in the settlement process if you have an informed client who's thought through what success means, what it would mean to win in settlement. If you don't do that, you might face what we call sort of the receding goalposts. If the client says 50, and I succeed in getting 50, the client may say, well, you made it so easy to get 50, how about 60? How about 70? And so unless you have a clear understanding in advance, you can end up with a challenge in terms of clients, because clients may want more than what you negotiated for. So in general, the guidance is have a clear agreement in advance with the client about settlement ranges or numbers or terms or structure. At every stage along the process, it's important to keep the client informed so that when you end up with an agreement, the client doesn't experience buyer's remorse, doesn't say, well, woulda, coulda, shoulda, I might have done better, or no. What you want is a client that understands the process, is part of it, and at the end of it, when you reach an agreement, the client says, yeah, that's an agreement that works for me. Not that they got everything, but that they have an agreement that works. So client satisfaction is a function of client expectancies balanced out by reality and the negotiation process. The second part of that is ethics in communicating settlement proposals and offers. I would say all good lawyers make it their practice, whether they're settlement counsel or not, to communicate offers and proposals to the client to make sure that they have informed consent. It is reckless to say, we have a deal, let me check with my client. You do it the other way around. That sounds like an interesting proposal. It sounds like we might have a good deal. Let me check with my client and I'll get back to you. There's another part of settlement counsel ethics that required some attention, and that was under the older system in the United States, we pledged to be zealous advocates for our clients. Now, zealotry has been taken out of our vocabulary, but there was still the question, how could you effectively represent a client if, like collaborative law, you agreed that you were never going to try a case? So in most jurisdictions, there were ethical guidelines given by that state authorizing people to limit their practice in certain ways. And one of the ways that you can limit your practice is to say, for this engagement, the scope of the engagement is limited to representing you for settlement purposes only. And provided that it's in writing and you have informed consent, in most jurisdictions, by rule, by guidance, or understanding, acting as settlement counsel is ethical. In the same way, collaborative law faced the same challenge and with the same result. In almost all jurisdictions, didn't require any special rule, just a clarification and understanding that this was a practice limited to settlement of cases. Well, I think that the first quality is almost expressed as a commitment, a sincere, genuine belief that in most cases, in most business disputes, an amicable resolution, that is, informed consent participated by both sides, and a notion of satisfaction rather than total triumph or capitulation, is the mindset that's required. If you believe that the only thing you want to do is to try cases and to win at all costs, you're not suited to be settlement counsel. You may be the best trial counsel around, and your client may be well served by having you as trial counsel and me as settlement counsel. The second aspect of that is you have to have a dose of humility. We live in an uncertain world. There's no such thing as a sure and certain case. There's no such thing as perfect knowledge. And so in the course of settling a case, unless you're arrogant to believe that you know everything there is to know, with a dose of humility, you can be genuinely curious about understanding the needs and the interests of the other side. You can be genuinely curious to find out from trial counsel the strengths and weaknesses of the case if the case were to be tried. And you can be genuinely curious to find out from your client what their real interests are. So it's that notion of, I don't know everything, but I'm curious to know everything. I want to know what the other side needs. I want to know what my client wants. I want to know from the litigator, realistically, what are the alternatives? What are the driving issues of law and fact that will make this a strong case or a weak case? So I think those are the first two qualities that I would start with. I think the third one is you have to be optimistic. And optimism in this sense. First, as an article of faith, I believe that most people are well-intended. I believe, particularly in the business community, that most businesses and most business people are well-intended. They're not crooks, they're not thieves, they're not liars, they're not evil people. So most of the time when there's a business dispute, it's because there was some failure of communication. Now, that's an expression of a worldview. I'm an optimist. I think most people are decent and good. If you believe that, you can then also believe that in most cases, an amicable settlement by informed parties is superior to war or trial. So you can be optimistic about the process. If we engage in good faith and with goodwill, we will find solutions to these problems. So, patience, humility, optimism. Start with your own client. Professor Sander from Harvard Law School, when I was giving talks on this at Harvard, said, you know, it does require a special skill, and only a lawyer could say with a straight face to the client, hire two of us, we'll save you money. And yet, I think that is true. I obviously practiced that way for 15 years as settlement counsel, and I firmly believe even now, though I'm just a mediator these days, that it is cost effective to engage in settlement counsel. Two reasons why that's true. The first is that litigation process in the United States takes a long time. Every day that you spend in the litigation process costs more money. True on both sides. The longer you're in the process, the more money you will spend. Most of the time the case will settle, okay? 90%, 95%. So it's not whether, but when. And the longer it's in it, the more it costs. So the savings for your client is getting it settled sooner, because sooner means either more money for you or less money that you have to pay, but certainly less money you have to pay for the transaction of being involved in litigation. If it's true for your client, it's as true for the other side. Once people think about the difference between trying a case and settling a case, on both sides they then understand that even the very questions that you ask are different. Okay, there's not much of an overlap. A trial lawyer asks this question, what happened? And a trial in a courtroom is a restaging of some event that happened in history, in time and space before today. For the most part, settlement counsel really doesn't care what happened. The framing question is, what do you want to happen? How do you want this day to end? What would it mean to end up walking away with a workable settlement So it's forward-looking, and litigation is backward-looking. If you draw Venn diagrams, there's about a 10% overlap of facts between trial work and the work of settlement counsel. Most of the time, what drives a settlement is not what would happen in court. Okay, it's part of it. Okay, I have a strong case, I have a weak case, but it's only part of it. Most of the facts that matter are, what are the business objectives? What are we trying to accomplish? What are our interests? What are their interests? And how can they be harmonized? In fact, there are some companies in the United States that will say to their outside law firms, look, we need to have both. We need to have trial lawyers and we need to have settlement counsel. We want your team, your dispute resolution practice team, to be trained to do both. And so on this case, the A case, you're going to be trial lawyer. On the next case out, the number 2 case or the B case, you're going to be settlement counsel. We're going to work with the same group of law firms. We're going to trade back and forth to keep your skills in both arenas up. What you can't do, really, is to say I'll be settlement counsel and then I'll be trial counsel. Okay? Because that's the same thing as saying, well, I'm just hedging my bets. The language, the literature, the agreements, the commitments, the undertakings you have are different. So you can have a mixed practice. Now, in my case, for the intellectual property group at my firm, I was their settlement counsel. For the insurance group, okay, I was litigation counsel. But for IP disputes, I knew enough about resolving the disputes to mediate, to act as settlement counsel, but I wasn't trained to try those kinds of cases. So we had strength, all of my ADR skills, to tell a client base, including new clients to the firm, you get 2 for the price of 1. You get settlement counsel, try to settle the case, and you get us the best at trying cases. So you could pick an area and say, in this area I will be settlement counsel. You can alternate cases. You could have a practice group that says, on this case, Joe will be settlement counsel and Bill will be trial counsel. Now, sometimes, about half the time, the trial team was somebody inside my law firm, and about half the time the trial team was from some other law firm. So both models work, and yes, in 1990 I was settlement counsel on 1 case and trial counsel on 5, say. Over time, the percentage has changed. It's a question of developing your skill sets and then being in a position to promote and market yourself as being more than just a trial lawyer. John Landy, he wrote a book on early intervention, and he talks about a whole range of techniques for resolving disputes earlier, and among them Bliss Settlement Counsel was one. Obviously we've talked about collaborative law, and there are other techniques that are out there. So it's not one thing in isolation to the full spectrum of choices. And it doesn't mean for any one lawyer that I'm either a trial lawyer or I'm settlement counsel. You can say I'm trained as settlement counsel, I'm trained as collaborative law, as a collaborative lawyer, and of course I'm trained to be a trial lawyer.